I'm injured from an accident. The doctor said that I need to go for surgery next week, but my case against the perpetrator doesn't end until 3 months. I also don't have the money to pay. What should I do?
Actually, you can consider applying for an interim payment order. So now, we'll be looking at the procedures of applying for an interim payment order. First, when can we make the application? An application for an interim payment order may be made at any time after the service of a writ and filed before the expiration of the time limited for the defendant to enter an appearance pursuant to Order 22A, Rule 21. And under Order 12, Rule 4A, the defendant is required to enter appearance within 14 days from the date of service of the writ. And where the defendant fails to do so, the plaintiff may obtain a default judgment against the defendant while pursuing an interim payment application at the same time and continuing the action against other parties. But then, what are the forms needed for the application? The application itself must be made by filing a Notice of Application in Form 33, supported by an affidavit in support in accordance with Order 22A, Rule 22. But what should I include in the affidavit? According to Order 22A, Rule 3, there are 3 requirements governing the affidavit. Firstly, it must verify the amount of damages, debt, or other sum to which the application relates, and the affidavit must state the grounds for the application. It must also exhibit the documentary evidence relied upon by the plaintiff in support of the application. While these requirements are important, however, the Court Utama held that technical defects in the evidence will not defeat the application because the court accepted that valuation is not an exact science and may be based on approximate or even opinion-based evidence, provided that the amount claimed is reasonable and supported. Similarly, in Stalin Timber, the court held that it is not necessary for the affidavit to address future liability scenarios. On another note, what if my claim is under Part 3 of the Civil Law Act? While the claim falls within Part 3, relating to fatal accidents and survival of cause of action, the affidavit must additionally state the full particulars of the person for whom and on whose behalf the action is brought, as well as the nature of the claim. With that, once the notice of application and affidavit have been prepared, they must be served on the defendant. Under Order 22A, Rule 24, the documents, together with all exhibited evidence, must be served not less than 14 clear days before the hearing date. As Order 22A does not prescribe a specific mode of service, Order 62 Rule 6 applies, requires service by ordinary mode. Now that the interim payment order has been obtained, who should we make the payment to? Once the court grants the interim payment order, Order 22A Rule 5 governs the manner in which a payment is to be made. As a general rule, under Rule 5.1, the payment is to be made directly to the plaintiff unless the court orders that it is to be paid to the court. Where payment is made directly to the plaintiff obtains the immediate benefit of the sum awarded. Alternatively, the court may order that the sum to be paid to the court with the funds remaining under the court's control. And in such cases, the plaintiff may subsequently apply for the whole or part of the sum to be paid out, and such application must be served on the other party pursuant to Rule 5.2. Additionally, under Rule 5.3, the court may order that the interim payment be made either as a lump sum or by installments, and under Rule 5.4, where the payment relates to a defendant's use and occupation of land, the court may order periodic payments to be made during the pendency of the action. Furthermore, in regards to interim payments, there are also ancillary matters that we must take note of. Firstly, Order 22A Rule 9 operates as a corrective mechanism because it allows the court to adjust, vary, or discharge any interim payment once the final judgment has been delivered or where the action is discontinued. Through Rule 9, it ensures that the interim payment ultimately corresponds with the claimant's actual entitlement as determined at trial. A common situation would arise where the defendant ultimately succeeds in the action, and in such cases, the court may order that the interim payment be repaid either in whole or in part. And similarly, where the final damages awarded are lower than the interim payment, an adjustment will be made to the account for the excess. Next, Order 22A Rule 11 provides that even if substantive requirements are satisfied, the court is still precluded from granting such an order if the defendant is the government. And it should be noted here that the government here concerns only state and federal government, not statutory bodies. And it should also be noted that an application for interim payment may be combined with an application for summary judgment under Order 14. This is procedurally efficient as both applications are premised on the strength of plaintiff's case and the absence of a real defense. Where appropriate, the plaintiff may therefore seek both remedies concurrently within the same application.
After I submitted my application, what happens in court? What will the court consider?
In order for the court to determine whether to grant an interim payment order, it must go through a two-stage process. At the first stage, the plaintiff must satisfy one of the disjunctive preconditions under Order 22A, Rule 3.1 or Rule 4, depending on the categories of the claim. If one of the preconditions is satisfied, the court will proceed to the second stage and decide whether it thinks fit to order interim payment, and if so, what amount is considered just based on the circumstances. The burden of proof lies with the plaintiff applying for the interim payment, and the standard of proof is on the balance of probabilities. However, it is not enough to show that success at trial is merely possible or likely. The plaintiff must adduce evidence before the court that he will likely succeed in obtaining the judgment of substantial sum sought. Rule 3.1 sets out 3 preconditions for an interim payment order in an action for damages. The plaintiff must fulfill one of these preconditions in order to satisfy the first stage of the two-stage process. Rule 3.1 para A is on admission of liability. Under this para, the court may grant an interim payment if the defendant has admitted liability for the plaintiff's damages. The important point is that there must be a clear admission of liability. In Bunga Raya, the High Court made it clear that mere silence or mere failure to dispute or deny a demand is by itself insufficient to constitute an admission. This principle in Bunga Raya ensures that Rule 3.1 para A cannot be easily triggered by ambiguous conduct, meaning that the admission must be sufficiently clear. Rule 3.1 para B is on judgment with damages to be assessed. In Joseph Engineering, the Court of Appeal explained that interim payment may be made where a judgment has been obtained, but damages are to be assessed later. It is intended to relieve the plaintiff from having to wait until the assessment process concludes, and the focus is solely on assessing whether it is fair to make an interim payment on the amount of damages already owed. Rule 3.1 para C is the most frequently invoked preconditions in interim payment cases. Joseph Engineering affirms that this para allows for interim payment when a plaintiff has a very strong case against the defendant, even if liability remains in issue. This means that if the action proceeded to trial, the plaintiff would obtain final judgment and the defendant would be held liable to pay a substantial sum of money. However, if the claims are related to sums other than damages, the plaintiff must then satisfy one of the disjunctive preconditions under Rule 4 to satisfy the first stage. Rule 4 para A relates to order for account. It is an order for account that a court directs to investigate into the sum owed arising from an agreement between two parties. And under this para, if the plaintiff has obtained an order for account to be made between him and the defendant, and the amount owed has been confirmed or certified, then the interim payment may be allowed, requiring the defendant to pay the amount due. And in Justin Ong, the trustee who caused the delay in the distribution of the money admitted to the amount of money owed from the trust fund account. The court ruled that such acknowledgement of the amount meets the requirement of having the amount certified under Rule 4 para A, and therefore, interim payment order is granted in favour of the plaintiff under this para. Rule 4 para B is related to a specific claim for possession of land. In Starling Timber, interim payment order was granted under this para as the court was satisfied that first, the action involves a claim for possession of land, and secondly, the defendant remains liable to pay the plaintiff monthly rentals for the period the defendant used and occupied the land while the case was pending, even if the final judgment at trial may be in favour of the defendant. Rule 4 para C is the counterpart to Rule 3 subsection 1 para C, but it applies to non-damages monetary claims. The recent case of Sid Advisor provides a clear illustration whereby the plaintiff sought interim payment for outstanding sums due under a ticketing system. It was held that the plaintiff had shown on the balance of probabilities that it would obtain judgment for a substantial sum of money apart from damages or costs. The English case of Small Man Construction further makes clear that Rule 4 para C is not satisfied merely because the plaintiff shows a prima facie case or a strong case. Instead, the court must look at the likely outcome of the case if it proceeded to trial, while considering the plaintiff's claim and any set-off or counterclaim that could reduce or offset the amount owed to the plaintiff. The defendant, on the other hand, may oppose or resist the plaintiff's application for an interim payment on two grounds. Firstly, objections under Rule 3, subsection 2, and secondly, on the merit of the plaintiff's application. Firstly, objections under Rule 3, subsection 2, para A to C. Under this rule, an interim payment order for personal injuries could only be granted if the court is satisfied that the defendant is insured against the plaintiff's claim, a public authority, or a person with sufficient means and resources to make the interim payment. Therefore, if the defendant can prove that he is unable to make the interim payment or he is not a person under this rule, he may raise an objection to resist and set aside the interim payment application. Secondly, on the merits of the plaintiff's application. As explained earlier, since the duty is on the plaintiff to show that he will recover substantial damages at the end of the trial, the defendant can oppose an interim payment application on the merits by demonstrating that there is a serious doubt as to whether the plaintiff will recover any amount at trial.
Now, moving on to the second stage, The second stage of the process is further divided into two parts. First, the court, having regard to relevant factors, will decide whether to exercise its discretion in granting an interim payment order, and number two, determine the quantum of the interim payment order. So an interim payment order would not be granted in cases with complex question of law. As seen in Josu Engineering, an interim payment order would not be granted if the court has to spend hours on the factual issues or difficult points of law which require citation of many authorities in order to resolve the matter. However, as seen in Seat Advisor Sdn Bhd, the court can still consider interim payment order if there is clear evidence that show a minimum amount is likely to be recovered by the plaintiff with reasonable certainty. Importantly, the court only requires reasonable certainty to be proven rather than absolute certainty or the minimum sum likely to be recovered. Next, an interim payment order may be granted if the plaintiff can prove hardship. The plaintiff must demonstrate that he has suffered hardship which warrants the court to exercise its discretion to grant interim order. However, the plaintiff need not prove real hardship, as seen in Josu Engineering, where the court held that monies and amount due to the plaintiff which has been withheld for more than 10 years causes hardship to the plaintiff. However, in Mega Mesa Sdn Bhd, court established that future losses cannot be deemed as hardship under the order. The hardship has to be present and immediate financial hardship suffered by the plaintiff. It is worth noting that a civil litigation delay does not amount to a hardship suffered by the plaintiff. This is because it does not amount to any type of exceptional hardship, as such inconvenience is an inherent feature of civil litigation which every party in the suit will face. Next, the court does not consider the plaintiff's financial needs, use of funds, and alleged prejudice in granting interim payment order. It is well established rule in Josu Engineering case and David Chelia where so long hardship is proved, the court will not concern itself whether the plaintiff requires the sum to meet its need, how the money will be utilized, or whether any prejudice would be suffered if the interim payment is rejected. As explained in Seat Advisor, this is because such legal issues will be determined later on at a full substantial hearing of the suit. Furthermore, it should be noted that interim payment orders are not confined to personal injuries action. It also extends to a wide range of proceedings such as contractual claims, wrongful death actions, product liability claims, wrongful dismissal, trespass to land, misappropriation of funds, and claim for property damage. After exercising its discretion to grant an interim payment order, the court will then proceed to determine the appropriate quantum. In determining the quantum, Order 22 Rule 3 requires the court to consider reasonable proportion of damages which is likely to be recovered by the plaintiff. The court's approach to what constitutes a reasonable proportion has been developed over time and will be discussed in three stages: pre-Josu Engineering, Josu Engineering, and post-Josu Engineering. The courts in determining the amount to be paid have consistently been guided by the principle of what is considered just and in reasonable proportion. Prior to Josu Engineering, the courts will usually refer to cases with similar facts to gauge the trend of damages awarded after a full trial. For example, in Media House Sdn Bhd, the court referred to comparable cases involving breach of employment contracts with similar facts in determining the amount to be paid. David Chiller had demonstrated this as the courts held that the 250k claimed by the appellant is too excessive, as the trend of damages awarded in similar cases had ranged between 50,000 to 60,000. So accordingly, the court determined that 50,000 was a reasonable sum for interim payment as the minimum amount the plaintiff was likely to recover at trial. In 2016, the Court of Appeal in Josu Engineering had set out guidelines of factors to be considered by the courts in determining what amounts to reasonable proportionate and to the amount likely to be recovered by the plaintiff. The court have listed out 7 relevant factors to be considered. First, damages likely to be awarded. 2, danger of overpayment. 3, disregard the usage of such payment. 4, the existence of any counterclaim or contributory negligence. 5th, whether the money would be used in intentional prejudicial manner to any subsequent issue in the trial. 6, respondents' resources. And the final one is the strength of the case. However, it's important to note that the court had emphasized that it is fact-based, meaning that the quantum depends entirely on the circumstances of each case. The list of factors does not dictate a final determination of the amount to be awarded. Although the Court of Appeal in Josu Engineering sought to provide guidance by establishing those factors, subsequent High Court decisions have continued to adopt a piecemeal approach in determining quantum on case-to-case basis. This is not necessarily problematic, as Josu Engineering itself had made it clear that such exercise is factual-based, dependent on the uniqueness of the circumstances of each case, and that the listed factors are not exhaustive. The court should not be constrained by a rigid template, but should instead rely on the factors provided in Josu Engineering to justify the amounts awarded. This approach has been reflected in MRA International Sdn Bhd, where the court acknowledged that relevant factors and having considered them, justified its award for 2.5 million ringgit Malaysia. Similarly, in Tiu Sai Hong, the court held that due to the uncertainty of final outcome of a trial, the court awarded 50% of the 400k as an interim payment. So therefore, the courts will determine a quantum that is just and within a reasonable proportion based on the facts of each case. However, the defendant may challenge the quantum of the interim payment by arguing that after considering contributory negligence, set-off or counterclaim, little or nothing will ultimately be owed. This was seen in small man construction, where the defendant's counterclaim for losses due to the plaintiff's delay could offset and reduce the plaintiff's claim.
Now let's look at Singapore's position.
Across the causeway, the Singaporean rules on civil procedure had evolved a step further.
While provisions on interim payments in the old 2014 Singaporean Rules of Court were largely identical to that of the current position in the Malaysian Rules of Court here at home, the Singaporean rules were amended in 2021 with the overarching aim to modernize civil procedure.
Yes, the new 2021 Singaporean Rules of Court had abandoned the two-stage approach, which is the preconditions and the court's guided discretion as is currently operative in Malaysia, and subscribed to a more simplified yet holistic approach.
Order 13 Rule 8 of the new Singaporean rules now allows the court to grant interim payment of any amount after taking into account 5 statutorily enacted factors that are intended to give the courts in exercising the discretion to make such an order. These are also known as the 5 factors. It is also notable that these 5 factors will also be applied to determining the quantum of the interim payment order.
We will now discuss those 5 factors. First, the amount of the plaintiff claim. For this factor, the court will consider first, the quantum of the interim payment claimed by the plaintiff. Second, the amount of the plaintiff claim in the main action. And third, the defendant's actual or expected liability. The smaller the quantum of the interim payment claimed in relation to the amount of the claimant's claim, the greater the indication that the interim payment was claimed only for specific and not extraneous purposes, and therefore that an order for such payment should fairly be granted. This factor will also set a ceiling on the quantum of interim payment which may be ordered by the court.
Now, the second out of those 5 factors is whether the defendant had admitted liability or had been found liable for any part of the claim, and if not, why the claimant believed the claimant had a strong case against the defendant. In brief, this factor combined the 3 previous preconditions set out in Order 22A Rules 3 and 4 of the Malaysian Rules of Court, as was discussed earlier. However, this is no longer a strict preconditions for the court's power to grant interim payment orders.
Yes, the court will consider third, why the claimant required an interim payment to be made at this stage of the proceedings. So in exercising its discretion to order an interim payment, the court would have to consider the hardship, the need or prejudice that the claimant suffered, and such an order would reduce the strain on public expenditure for the relief of such hardship.
Now, moving on to the fourth of the 5 factors, any contributory negligence, set-off or counterclaim that the defendant had relied on. Now, this factor was also retained from the Malaysian rules, and this factor is relevant to both the appropriateness of an order and the quantum of interim payment that the court should order. This is because, again, an interim payment order is, in essence, an imposition of liability before a judgment has been delivered.
And the final factor, the defendant's ability to make the interim payment. So while the new Singaporean rules did not make a defendant's inability to make interim payment as an absolute prohibition like in the Malaysian Rules of Court, the court should still give weight to this factor in deciding on whether to grant an interim payment. This is because the very purpose of an order for interim payment would be defeated if it was made against a person who was ultimately unable to make the payment.
Now, having looked at the Singaporean approach, we'll now discuss whether is their way really the better way. At present, Malaysia adopts the common law standard form provision, which mirrors the law that is applicable in the UK, Australia, Hong Kong, and other common law jurisdictions. While Singapore has left this party in 2021, the efficacy of its new rules is yet to be seen. The new Singaporean rules remain nascent and largely untested. The case of Ng Zi Liang is the first and only appearance of the new Order 13 Rule 8 of Singaporean Rules of Court in court to date. Nonetheless, it is timely to analyse the Singaporean approach for what it's worth and draw lessons from Malaysia.
Let's start by taking a bird's eye view of interim payment and gradually descend into a comparative analysis between the Malaysian way and the Singaporean way.
Yes, in our view, there are 2 aspects that must necessarily be considered when we're dealing with an application for interim payment. First, the need for interim payments to soften the impact of long-winded litigation on the plaintiff or sometimes the victim.
I agree. And the second aspect would be the dangers of interim payments in being construed as rendering a judgment against the defendant at an early stage of the proceedings. So the judge must be conscious that not all the evidence that might be adduced at trial is available, and that such evidence, even if it is available, has not been fully tested through the trial process. So if this discretion of power is exercised carelessly or without proper guidelines, an interim payment order is as good as punishing the defendant before his liability has been established.
Yeah, and in view of these two aspects, we can then safely conclude that the granting of the interim payment order is essentially a balancing exercise. The court needs to tread a fine line between the plaintiff's needs on one hand and the defendant's risks on the other. But fortunately, the courts are not left to themselves.
In Malaysia, the legal considerations that guide the court's discretion are encompassed in the two-stage approach, as discussed earlier. Conversely, the Singaporean rules have reorganized and condensed the same legal considerations into the allegedly more holistic 5 factors.
Importantly, this balancing exercise is now been recognized by the Singaporean court. The court there declared that the touchstone for the grant of such an order was that of fairness. The court must balance two aspects that we mentioned earlier, which are the need for interim payment to mitigate hardship and the prejudice that the defendant might suffer.
Therefore, at this juncture, we are of the opinion that the efficacy of a rule governing interim payments must be measured by its ability to guide the courts in carrying out this balancing exercise, and eventually assist the court in ordering or denying an interim payment order and its quantum that is fair and just in the circumstances.
I also observed that the new Singaporean rules did not reformulate the law on interim payments. It had merely reorganized and collapsed the same considerations that are operative in Malaysia today into the simplified 5 factors.
Yes, this reorganization cannot be construed as insignificant as the word may suggest, because the reorganized guidelines may have the effect of directing the mind of the judges to consider the application in a different way.
But it is also not easy to just compare the Singaporean rules with the Malaysian rules and conclude that one set of rules is better or worse than the other. At the same time, this reorganization also should not be simplistically seen as rendering the threshold lower or higher and the requirements easier or more difficult to satisfy.
The two-stage approach in Malaysia is sequential, whereby the application must first satisfy one of the statutory preconditions in the first stage before the court would exercise its guided discretion in the second stage. Singapore's departure from this structure now gives the court more room to consider interim payment order applications holistically.
Yeah, Malaysians' two-stage approach is a more structured way in that it allows better predictability of outcome, clearer thresholds, and less risk of arbitration discretion in the courts.
And not only that, it encourages judicial discipline by requiring judges to strictly assess the preconditions, which filters out cases that are not suitable for an interim payment order in the first stage and only apply its discretion based on judicial precedents in the second stage.
And now the Singaporean approach would warrant much more discussion from us. The preconditions in the first stage in Malaysia are no longer a strict threshold in Singapore. A Singaporean court may grant an IPO even if the plaintiff had not shown that the defendant would likely be liable to the plaintiff for a substantial sum of money at the end of the trial. Now, there are two sides to this. On one hand, this gives the court an expanded discretion to order interim payment where it appears to be fair and just, considering the other factors and ultimately by carrying out the balancing exercise.
But at the same time, the departure from the strict preconditions may risk opening the floodgates of interim payment applications. This would place an even heavier burden on the judges and strain judicial discipline, as judges are no longer bound by statutory thresholds. So, we think that the statutory preconditions are significant as they are a tool to balance between the plaintiff hardship and the right of the defendant not to be unduly deprived of his money.
Now that is important because it is in the nature of human beings, including that of the judges, to be sympathetic with individuals that are in hardship. Therefore, having strict preconditions would prevent judges from overlooking or ignoring the rights of the defendants.
Nonetheless, the final determination lies on individual judges assessing the facts presented before it. Altogether, it is obvious that the Singaporean Rules of Court 2021 had expanded the role of judges in carrying out the balancing exercise in granting interim payment orders. So unlike Malaysia's two-stage test, Singaporean courts would now have to answer a single composite question, which is, in light of all the circumstances, whether it is just and appropriate to order an interim payment at this stage in the absence of strict preconditions.
And in our opinion, we can then conclude that both the Malaysian and Singaporean approaches are distinct approaches with the common aim of requiring substantive and procedural justification for ordering interim payment order at this stage. But it is too early and premature for us to conclude whether which approach prevails over the other, and only time will tell.